First, I want to describe the court's powers here. Now, of course, the court has powers to set aside judgments under the CPR, the Civil Procedure Rules. But it also has what's referred to as the inherent power of the court to regulate its own proceedings. And although the case I'm illustrating here, Hunter and Chief Constable of the West Midlands, is not related to a judgment to set aside application, it does show the width and significance which the court attaches to this inherent power. So let me just read this out to you. The inherent power which any court of justice must possess to prevent misuse of its procedure in a way which, although not inconsistent with the literal application of its procedure rules, would nevertheless be manifestly unfair to a party to litigation before it, or would otherwise bring the administration of justice into dispute among right-thinking people. The circumstances in which abuse of process can arise are very varied. Now that deals with the second area. So moving on to the third area, which is after a trial without a defendant. So the situation I'm imagining here is that the claim proceeds. There's no summary judgment application, or if there is, it doesn't succeed. And the matter goes on to trial, but the defendant doesn't turn up at the trial. If that happens under CPR 39, the court has the power to carry on, to strike out the defence and to enter judgment against the defendant, but the claimant has to prove its claim. And I've been involved in one of these situations, which is a slightly odd situation where the defendant isn't there, but the claimant, and in my case, the claimant's managing director was giving evidence to prove its claim, which was for an unpaid invoice. The evidence was not very extensive. It simply required the managing director to say that services have been rendered at the defendant's request, an invoice has been submitted, the defendant had not paid the invoice, and there was no reason known to the claimant why he hadn't paid it, and no argument had been raised about the service. It was just silence, and the defendant wasn't there. So judgment was given. We had to go through the motions of proving the claim.